All rise. The Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable William D. Palmer, Judge, presiding. All persons having business before the court will draw near, give attention, and you will be heard. In God save the United States of America, the state of Florida, and this honorable court. Please be seated. Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Berger. To my left today we have Senior Judge Jacobus sitting with us. We have both criminal and civil cases on the docket today, 15 minutes per side on the criminal case, 20 minutes per side on the civil cases. The appellant can reserve as much time for rebuttal as they choose. After the first two cases, we will take our morning break, and the lawyers are invited to join us in the lawyers' lounge for coffee if they would like. The first case is Melendez-Rios versus State.
Good morning, Your Honor. My name is Mark McCulloch. I appear on behalf of the appellant, Mr. Melendez-Rios. Before I begin this morning, Your Honor, it is my privilege to note the presence in the courtroom of Mr. Michael Patrick. He is a law clerk in our office, a second-year law student at the Barry University School of Law. May it please the court. The appellant here had made a request of his lawyer to allow him to withdraw his plea. This plea was, the motion to withdraw the plea was prior to sentencing, and Rule 3170F.
Let me ask you this with regard, because we know that the judge summarily denied it. I mean, he filed it and the judge denied the motion. And there's an argument that the judge abuses discretion in denying it before giving your client an opportunity to be heard. Was an objection lodged at the time?
Objection by the lawyer was not necessarily lodged at the time. The argument that was made was simply the lawyer had informed the court that a motion to withdraw the plea had been presented, and this was after Judge Shea had said, so you're making an oral motion to withdraw the plea. No, Judge. Attorney Payas responded. It was a written one. It had been filed. Oh, okay, denied.
Well, but when it was denied, was there an objection lodged at that time that he had not given his client an opportunity to be heard on the motion, or him an opportunity to be heard on the motion?
The lawyer did not make that objection, although I'm not convinced that that's necessary in this context. And the reason I
did get heard, there was a hearing, ultimately, was there not?
I would scarcely want to characterize it as a hearing, Your Honor.
Well, I mean, he got to answer questions, the judge asked him things, did he not?
The judge spent a considerable amount of time telling Mr. Melendez-Rios why he wasn't able to withdraw his plea, not necessarily engaging him in questioning, but rather dictating and pronouncing from the bench, in essence berating him in saying, look, no one was twisting your arm behind your back, no one was forcing you, I looked at you, I didn't hear any of this, I didn't hear any...
But he didn't get to proclaim, he told the judge that he was innocent of the crime, he wanted to withdraw his plea, though. He did tell the judge that.
He did tell the judge that.
And the judge inquired of defense counsel at that time as well about some of the issues that were raised in the motion, that he had been, threatened or told to lie and various things.
The engagement was not necessarily with trial counsel. Trial counsel interjected at the point where Mr. Melendez-Rios was being essentially told by the court, your reasons are nothing more than buyer's remorse. I don't buy it. I'm not letting you withdraw your plea. And the point that I think is important for the court to recognize is that prior to any engagement at all by Judge Shea of the defendant whether it was statements made to him, essentially telling him why he wasn't going to be able to withdraw his plea, or otherwise. The point is, the judge summarily denied the motion to withdraw a plea without ever hearing anything
I got you.
about that. It's the
I
equivalent.
got you, but that's why I asked you, was there an objection raised? Because I'm concerned about whether or not there was, the error was preserved below. I mean, we're an error-correcting court, so you have to let the trial judge know that they may have done something wrong by objecting before you come up here to us. So that's my concern. I agree with you that the judge should have heard him on his motion before summarily denying it. My question is whether or not that error was preserved.
I believe it was by virtue of the motion, the filing of the motion to withdraw the plea, and the context of the summary denial, the context of the hearing.
Yeah, but you have to object to it. I mean, how?
There's no rule that I'm aware of that requires that objection to be made on the record in order to preserve this issue for appeal, Your Honor.
Make it in writing to the judge?
I wasn't the plea counsel, Your Honor.
Well,
That's not my...
You're familiar with the record, though. I mean,
There was...
Is there an objection in writing after the fact that, or a motion to rehear, that the court ruled without providing my client an opportunity to be heard? Was there any objection lodged either orally at the time of the hearing or within the time frame for rehearing afterwards?
There was no written objection or motion for rehearing because Mr. Payas had moved to withdraw,
So
which
if
the
there-
court granted.
So-
It's the equivalent, Your Honor, it would be the equivalent of this. This court graciously agreed to hear my argument this morning. However, a week ago, this court had issued an order denying my appeal. But come up here and let me make my argument anyway. Having already denied my appeal, having already denied the issue, if we want to go through the exercise of some kind of plea, some kind of hearing, or some kind of suggestion that due process and fairness was observed, it rings a little hollow in that, and in the context of this case, where
It seems as though he got a semblance of a hearing. What more would he say? He would say, my lawyer coerced me into doing it, right? I mean, I was forced into it. I'm really, Judge, I'm innocent. What more is he going to say? And then if you look back at the colloquy, when he took the plea, the judge asked him that, and he said, I wasn't, and then, I mean, we're always faced with that on withdrawal. You get remorse for whatever reason. It seemed like it was an awful good plea deal to me, but be that as it may, does he really want to be at risk? Does he really, want to have a trial and, face something else? I mean, really?
the short answer is absolutely, Your Honor. It would be, and this, in the context, it's important in the context as well, that this was not a last-minute issue. This wasn't the morning of the sentencing saying, no,
That's
I'm not.
because he got some extra time to write his apology letter and go to anger management, and he wasn't going to have any probation if he did those things, correct?
That's what the plea deal was.
Yeah.
That's what it was offered. And in fact, when Judge Shea announced on the record that he had provided extra time between the time of the plea and the time of the sentencing, that was correctly stated by counsel that was a part of the plea agreement.
I don't understand your preservation argument where you said you think it is preserved simply by filing the motion to withdraw the plea. How does filing the motion preserve an error about how the motion is decided by the court or any what you perceive to be procedural or due process issues?
There are two ways that I would respond to that, Your Honor. The first one is this. At the time that the colloquy was engaged in, after the court had already told Mr. Melendez-Rios that his motion was being denied, it was denied. So, okay, now go ahead and tell me something. Mr. Melendez-Rios, at the same time, was essentially without counsel. And as such, as a pro se defendant, the court is invited to provide
You'll have to preserve your error, right? Even if you're representing yourself pro se, if you don't make the argument below, we can't say the trial court erred by not agreeing with your argument, unless it's fundamental error.
Well, I think as a matter of, I think there was an argument that we presented, I believe that would address a fundamental error question. It's an error of law.
Well, you have to argue, if the error is not preserved below, and I don't believe that the error was preserved below, you have to argue fundamental error on appeal. And I could not find a fundamental error argument in your brief. I mean, we're not required to do an independent fundamental error analysis if it's not argued in the brief.
I would agree with that certainly in general, Your Honor. However, in the context of this case, in the facts of this case, I don't believe that.
Well, what in the facts of this case makes it any different than any other case where an appellant has not preserved the issue for appeal?
I think it makes a difference. I think it makes a difference in two ways. One, the colloquy itself suggests an objection.
Point to me in the record where there is an objection in the colloquy.
There's no specific objection in the colloquy, Your Honor. But in the context of the colloquy, in the context of what had transpired, the context, I believe, makes it, at least, it makes it plausible from the record, from this record.
Well, it also makes it plausible that the trial court gave him a hearing, let him be heard on his motion, even though he'd already ruled on it. I mean, he was given an opportunity to change his mind. He heard the evidence, or heard the testimony from Mr. Rios, and heard counsel's testimony as to why he made the decision or why he gave the advice he did to his client. And then the judge continued on with sentencing and didn't change his mind on the ruling. I mean, he did get to have somewhat of a hearing, although perhaps truncated.
Judge Shea had made up his mind and wasn't going to change his mind. He already indicated that on the record. We had a deal. That's what his words were. We had a deal.
I'm with you, but I don't see, I mean, I've read back through it. There's no objection. I don't see how you can say, well, just having a conversation with the court after the fact and maintaining his innocence, which Mr. Rios did, is an objection to, I mean, it might be a pleading for the court to change its mind, but it's not. Judge, you made a ruling, you did not give me an opportunity to be heard on the ruling, and I object and would like an opportunity to be heard. I mean, that was not said by anybody.
And I don't disagree with that, Your Honor. If I may, I'd like to reserve the balance of my time.
A little less than 3 minutes.
Thank you, Your Honor.
Good morning. May it please the court. My name is Allison Morris, and I represent the state on the appeal. The first point I would like to make is I do believe that the hearing did occur. It was adequate. The trial court did initially state that the motion to withdraw was denied, but then he brought the defendant in. The defendant was sworn. Questions were asked of the defendant. Defense counsel testified. The trial court found there was no basis to withdraw the plea. The trial court did not abuse its discretion because I think there is enough in the record supporting that ruling. That is my position at this point. Does this panel have any questions? Okay. With that, I would ask that this court affirm the trial court's ruling, and have a good day.
Let me ask you this. Preservation aside, I was not able to find one, so I don't know if you were able to find a case that since it's the defendant's, has to establish good cause, is there a case out there that holds that asserting one's innocence, which is essentially Mr. Rios' argument, that asserting one's innocence is enough to establish good cause to withdraw a plea?
Your Honor, I think that the Guerin case here in the Fifth, when it talks about, when it goes through what good cause is, what does it mean to have good cause? The end of the discussion, the end of the phrase, is the ends of justice would allow or would be served by allowing withdrawal of the plea. Granted, that's a catch-all phrase, but I do think that a declaration of innocence, not once, not twice, but multiple times, in the face of the trial court essentially telling my client that he wasn't going to be allowed to withdraw his plea, nobody was twisting his arm behind his back, nobody was forcing him to do this, despite protestations, the protestations of his own innocence. The court, I believe, should have found that those protestations of innocence amount to good cause shown. And as such, under the under the 31F standard, good cause shown, the court shall permit withdrawal of the plea, pre-sentencing. There's a reason that 31F is a defendant or more defense-favorable standard, and it's because, as the Florida Supreme Court has said, courts are encouraged to liberally grant motions to withdraw a plea pre-sentencing because it favors a trial on the merits. My client's protestations of innocence are enough, I would argue, to fall within the ends of justice are served by allowing him to withdraw his plea. As the court noted, the plea was a relatively favorable deal.
Pretty good deal.
But he proclaimed his innocence multiple times. I want to go to trial, Judge.
People proclaim their innocence but take really good deals. That's not unusual in a criminal court context.
My client did not. My client said, no, I am innocent. I want to go to trial.
After he had entered his plea.
Which he said he was told by his lawyer to make sure that he made those statements to the judge because the judge wouldn't accept the plea.
And the lawyer said that wasn't true, and doesn't the judge have the right to judge credibility? And the judge didn't believe, apparently based on his ruling, that Mr. Rios was forced or threatened to enter the plea.
He made all of those statements, Your Honor, and came to all of those conclusions without hearing from trial counsel before he made those statements. That's clear from the record. How can he make those credibility calls during a brief time at a hearing? Court is not, the trial courts are encouraged not to do so based on a brief appearance at a hearing.
Well,
my time has expired, Your Honor, but may I?
Go ahead. Anything else?
No. Thank you.
Thank you, counsel.
Thank you, Your Honors.